Hitting the pause button on this testimony so we can bring in our guest to discuss. Joining us this hour, national trial attorney Michael Jaafar is with us. Michael, I want to share with you something one of our viewers on Twitter X mentioned about a time that they spent on a jury, and they said things seemed to be going great for the defense until, or one of the sides, but until the attorney started really treating a witness badly that didn't deserve it, and that really turned them off to that attorney's position. This defendant has some fantastic attorneys this time around, but what do you think about how they're handling this particular witness?
I think, it's a little bit awkward. They're not being too abrasive, but I'm so happy you said that because I've said this multiple times, and we've seen cases here on Court TV where I've always said, the defense attorney was too abrasive. We've seen cases, Julia, where the defense attorney would be abrasive to a witness who was also a victim of the defendant, right? Because the defendant had some sort of a scheme. So I'm a big believer in courtroom cadence, courtroom body demeanor, and the defense attorney. The biggest annoying thing for a defense attorney is when your client walks in your office and says, I need a pit bull. I need you to go in there. I need you to beat people up. That's not how it works. You get further with honey than you do with vinegar, right? And so I think that these defense attorneys are doing an okay job. It's a little bit awkward. This defense attorney specifically is being a little awkward, but they could be doing a lot worse. They could be doing a little bit better. But, I can understand that it's the nature of a retrial. So.
Yeah,
we'll see.
And it feels like the longer that he's on the stand, the more this jury is thinking about that affair, which prosecutors don't have to prove motive, but that's not a bad motive in terms of this. Also, I noticed that a statement was said. He was able to talk about what Linda told him about the fire. She told him she was downstairs and she had been arguing with her husband, and then she heard his voice change in tone, and she went to see what happened. It's a little different than what she told police. She said she was just downstairs doing laundry when she heard a scream and ran upstairs. Does that matter?
It absolutely matters, and she's had inconsistent statements with this boyfriend, with what she told police, with the property damage claim she did with the fire. So she's been inconsistent. There's a reason why this woman was convicted, right, the first time around. A jury looked at all the evidence and they said, you know what, you did this, right? And it was circumstantial, but it was still circumstantial enough to get her guilty beyond a reasonable doubt. So her statements have been inconsistent. She had this. It's never good for a defendant when you're a defense attorney, your client has been having an affair and she's charged with murder. It's never a good thing. It's always a bad thing. So her inconsistent statements are gonna, they're gonna lean against her when the jury is weighing her innocence or guilt.
Yeah, we're going to see how her former lover fares under the rest of this cross-examination after this quick break. We'll get you right back in. Let's bring in, while we wait for that, national trial attorney Michael Jaafar is with us. And Michael, I want you to put aside what we know about the conviction, the overturned conviction in this case, because the jury doesn't know about that. And I want to know if this affair, just on its face, by itself, is that enough of a motive to point to this defendant being someone who would light her house on fire, burn her husband, run him over with the car, and abuse him before all of that, is what the prosecution alleges.
On average, it's not enough, but this is a Kalamazoo jury. Kalamazoo jury, this is a very rural part of the country, very old-fashioned part of the country. This is like basically, I'm from Michigan, so I can say this is the middle of nowhere in terms of Michigan, right? These are types of people who, they stay married. So an affair would be distasteful to them. Still, in my opinion, it's not enough because what she's alleged to have done is so dramatically, so like you have to be a really devious, nefarious, an amoral person to burn somebody who you're married to and then run them over intentionally, right? So is the affair enough? No. And I noticed that the attorney, when he was cross-examining him, he asked him several questions, and one of them is, did she give you money? I think that was a nod to the jury that, hey, maybe this person was a loafer, he was a hanger-on, and he wanted things from her. He had nefarious motives, he wanted money. I think that was his point of asking that. So I think this affair enough. I don't think it will by itself make the jury think, yeah, beyond a reasonable doubt she murdered her husband. It's never good to have an affair, obviously, in a situation like this. It always gives the jury a motive to believe that you had the motive to kill somebody, but I don't think it's enough by itself.
All right, let's go back in and hear what these jurors have to say to this witness on the stand. Jury questions. First, the jury gets to ask theirs, and then the attorneys are allowed to follow up questions, have follow-up questions rather, with the witness to make sure that whatever the question leads to, that the jury can get the full picture from it. So that's why you still hear a bit of direct and cross from the attorneys. Let's bring back in Michael Jaafar, who is watching along. What do you think about these questions? The two that they have were, did you ever go to the home after the fire or at all? And how many interviews did you have with detectives? Which the answer was one. Are they reading more into his involvement at all?
I think what's pretty clear is that timing mattered to this jury. So maybe this affair had more of an impact than I thought. You'd asked earlier how big of an impact. I said it would have an impact because it's kind of a conservative jury. But those questions lead me to believe that it's even a bigger impact on them than I thought, because timing mattered to them. And yeah, they were also probably leading into, hey, why weren't you part of like a co-conspirator? Or why did they only talk to you one time? Maybe it was the question that the defense attorney asked him, did she give you money? Maybe that's what it is. I kind of don't know. It could cut both ways. Those jury questions and also those jury questions are not unanimous by the jury. They're individual jurors, right? So when the jurors go to debate this case at the end of the case, whoever juror asked that question, maybe one juror might think, if this guy was part of it, why wasn't he looked into? And another juror would have asked, hey, this was very bad that she had an affair. Did she have, was she close to you before, after, what happened? So each individual juror can ask their own question. And so it'll be this, you're kind of seeing what the debate will be like in the jury room after this case is done between those jurors that ask those questions.
Really good point, Michael Jaafar. Thank you for bringing that up, because that's one of the reasons most jurisdictions don't allow this, because it almost allows these jurors to start deliberating because they hear what another juror is thinking in these questions. Trial attorney Michael Jaafar, who is with us to talk about the Karen Read case. And Michael, I feel like I need to have a little asterisk by your name when you talk about the Karen Read case, because you are very pro-prosecution in this case, though we know your opinions are grounded in facts and the law. But tell me what you think about this request to the U.S. Supreme Court and this notion of there being a unanimous but unannounced verdict. I mean, if this was taken up, this would be big when it comes to what happens in the deliberation room and whether or not it could actually impact the outcome of a trial.
Here's my opinion on it. I think it's garbage. I think it's grandstanding. I think it strains credulity to even think that. I really, really believe this is grandstanding. By the way, I want to be clear. If I was her defense attorneys, I'd be doing the same exact thing, because I would want to take advantage of the spotlight in hopes that some jurors potentially will see this, because there's no such thing as pure jury sequestration. All the jurors that are going to be the jurors in this case are going to know about this case. Everybody in the country knows about this case. You can ask a barista and she'll know about this case. I think this is garbage. The thought that Judge Beverly Cannoni sent you back to the jury room several times you first jury, and each time you guys came back and told her, we are hopelessly deadlocked. The jury floor, Judge Beverly Cannoni wasn't in the room with you. She wasn't taking notes. She didn't tell you that you're deadlocked. You told her that you're deadlocked. You specifically told her, we are hopelessly deadlocked. You used adjectives to Judge Beverly Cannoni, begging her not to send you back into the room. I'm offended by this. I feel insulted. My intelligence is insulted. And I absolutely detest this thread, this line of logic, because in my opinion, this is to the jurors, you're either the dumbest people or one of you is lying. And I don't think it's the first thing. I think someone is lying. There is no way that Judge Beverly Cannoni sent you back multiple times, and multiple times you told her we are hopelessly deadlocked, but you were unanimous on the top charge. It makes no sense. What are we doing here? This is completely farcical. There's just no way that happened. One more thing. How could you be unanimous on the first charge and third charge, but not be on the second charge? It sounds to me like somebody's just lying.
Oh, Michael, it's not just one juror that's saying that. There have been several jurors who have come forward. I believe at this point it's the majority of those 12 who have come forward to at least the defense, the media, or to the prosecution to say, yeah, we were unanimous on not guilty. I agree with you. It's very weird that they at least didn't ask the judge, because I have seen that. I've seen jurors not know that they can bring back a partial verdict, but they will ask the judge, what if we're hung on one charge and not on the other? We'll see if this even gets reviewed by the Supreme Court in the amount of time, but the odds are that it is not, and we are going forward with this trial. But in talking about the jury, we've had some viewer questions about sequestration. You mentioned there's no pure sequestration, but why do you think these sides haven't asked for any kind of sequestration, even a partial? Once the verdict or once the jury is deliberating, they could just have them sequestered for that point in time.
I think the day and age that we live in, right? If you walk past that courthouse, your phone identifies that you're there, and it feeds you stories, and you start ingesting stories about it. I think it's just the law has not caught up. These sequestration rules were set up in a time before social media. They were set up until 10 years ago, 15 years ago. They work. They just don't work. I think the system's trying to catch up. I think at this point, if you're like Hank Brennan, for example, all you can hope for is you have a jury pool that does not have people who believe the earth is flat, complete morons, because that's what you need in order to believe the Karen Reed defense Bigfoot theory, right? That's what you need to believe it. So I think you just hope that, hey, we're not going to sequester these people. There's nothing we can do about it. Let's just hope that they're not complete morons. And after the first trial, a tear-soaked friend of John O'Keefe said that during the over 27 hours of jury deliberation, they kept hearing "Free Karen Reed," that silly chant, in their ears. So I think all they can hope for now is just to keep the public away and just hope for the best for the train wreck. So that's why I think that, Julia.
Michael Jaafar, thank you for your analysis this hour. We do have to get to a break.